First, I want to thank God for opening my eyes to see the truth and giving me the knowledge and courage to expose the truth. I'm going to explain the criminal complaint point by point with evidence, facts to support my claims, and all the links to the evidence are in the description of this video. I've learned to never take anybody's word at court. I always require them to show me the law, not a statute or code, but the law that they are relying on to support their actions and claims. And all have failed. They just lied and lied some more to cover up each other's lies. The people at court I've encountered are not honest or truthful. So I always ask, where's the proof? Because the truth can't become the truth without the evidence to support it, to make it a fact, to make it full of truth. And if you see my other videos, you'll see just how much they lie and how deceitful they are, and the things they will do to cover it up. So I now bring it to the people, the court of public opinion, with evidence, facts, the truth to prove the fraud, and I leave it up to you, the people, and ask, is this internal insurrection and or treason? You decide. District attorneys, judges, attorneys, and public defenders are all Bar Association members, and know that the United States and states' constitutions are the law, and are intentionally not following it, and are knowingly causing harm to the people with fraudulent criminal complaints. And from my personal experience, they are using the sheriff's deputies to hide behind and put fear in the people, so the people can't speak up and get the truth. But I don't fear them. I have God on my side. Now, some of the deputies are good guys and know something is wrong, but they say that they are just doing their job. Most are clueless and intentionally improperly trained, so I don't blame them, because we've all been lied to. But they all swore an oath, swearing so help me God, that they will support and defend the rights of the people. So let's start off at the top. It shows this document is e-filed. But if you look towards the bottom of the page, it reads, personally appeared, first being duly sworn. Now, how did they personally appear if it was electronically filed? They didn't. And that may be small to you, but every little lie matters when it comes to the people at court working for you. They are at all times to be honest, and no lie is acceptable when it comes to your rights. Next, we have Superior Court of California, County of Fresno. It's important to know what a Superior Court is, so let's find out. California Constitution, Article 6, Section 1. The judicial power of this state is vested in the Supreme Court, Courts of Appeal, and Superior Courts, all of which are courts of record. Now, a court of record is important, and I'll explain why and what it is later. I had to go to the Constitution of 1879, which is archived in the Secretary of State's website, because for some reason they left out a major part on the current Constitution, but this part is very important, and the 1879 Constitution is still just as valid today as the current Constitution. So California Constitution, Article 6, Section 12. The Supreme Court, the Superior Court, and here's the key verse, and such other courts as the legislature shall prescribe shall be courts of record. So this means only courts prescribed by the legislatures are lawful courts, and they are courts of record. And anything not prescribed by the legislature is not a lawful court. So it's family court, traffic court, municipal court, drug court, homeless court, or any of these other courts popping up, are they prescribed by the legislature? If so, they are courts of record, and courts of record follow strict guidelines from the Constitution. So it's important to understand what a court of record is, because those who work at court are not going to tell you and will deceive you and say it's a court that records. And yes, they record, but that's not all. So let's look at the law books to find out what a court prescribed by the legislature is, so we know what a court of record is and what it is not. We're going to go to California Jurisprudence, Volume 7, Courts, page 576, subsection 2, definitions. This part here is the key. It says, holding that the first essential of jurisdiction is a court having legal cognizance of the question, and that a court which is unconstitutional has no jurisdiction whatever. So we find out here that an unconstitutional court has no jurisdiction whatever. So a court has to follow the Constitution. It does not say statutes. I'll prove later that statutes are only for government and not the people. Jurisdiction basically means the court has the authority to act. So next we're going to go to page 578, subsection 4, classification of inferior courts. Inferior courts are those whose jurisdiction is limited and special and whose proceedings are not according to the course of the common law. So if a court doesn't proceed according to the common law, it's an inferior court and has limited authority. That's powerful. Now let's get the definition of a court of record. So this is page 580, section 5, courts of record. A court of record is a judicial tribunal having attributes and exercising functions independently of the person designated generally to hold it and proceeding according to the course of the common law. Now let's get definitions of a court of record from Law Dictionary, Black's Law Dictionary, 4th edition. A court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it, and proceeding according to the course of common law, its acts and proceedings being enrolled for perpetual memorial. Okay, so a court of record is the only court prescribed by the legislature, and it's a constitutional court. And in a court of record, the person in the black robe is a magistrate, not a judge. And the magistrate is independent of the court. He is not the court. He is to be impartial, and the court consists of the two parties, and the jury is the judge. And it proceeds according to the common law, not statutes or code. And the proceedings are recorded. Now, in order to make a record, the one giving the testimony, making the record, has to be under oath or affirmation, swearing what they are saying is true. Now, in 1815, the common law was adopted as the law of the state of California. Now, there's the English common law and the American common law, and they are different and separate. So the Constitutional History of California, Organization of the State Government, page 123. The common law was adopted as the law of the state. That's from the Journals of California Legislature. Now let's look at some definitions of common law, statutes, and penal code to determine what they are, and more importantly, what they are not, from the law dictionaries to find out some truth. I'm going to go to Ballantyne's Law Dictionary, 3rd edition. Common law actions. Forms of actions as they existed under the common law, being the ex contracto forms of account, assumpsit, covenant, and debt, and the ex delicto forms of denting, replevin, trover, trespass on the case, ejectment, forcible entry, and trespass. Yeah, I think I fumbled those words. And let's go to penal code and find out what that is. So penal code is a division of the statutory law. What's penal action? An action found entirely upon a statute. What's a statutory action? A remedy provided by statute which does not exist at common law. So common law basically has to do with contracts, breach of contracts, dereliction of duty, wrongful possession of property, a trespass, which is basically summed up of any harm, injury, or financial loss caused by one man to another man, and it's different than statutes. They are not the same. We further see here that penal code is a form of a statute, and that penal code and statutes are not common law. So far, this shows us that in a superior court, there must be a man making a claim under oath that another man has caused him some sort of harm, injury, or financial loss, or a breach of a contract, and must follow the Constitution, not statutes or penal code. Let's keep going. This is Bouvier's Law Dictionary, 1856. It says common law. That which derives its force and authority from the universal consent and immemorial practices of the people. It has never received the sanction of the legislature by an express act, which is the criterion by which it is distinguished from the statute law. Now let's go to Black's Law Dictionary, 5th edition. Statutory law, that body of law created by acts of the legislature. Common law, as distinguished from law created by the enactment of the legislature. Common law action, action governed by common law rather than statutory. Let's go to U.S. legal and get another definition of statutory action. Statutory action, law and legal definition. Statutory action refers to an action that is governed by statutory laws, which are laws enacted by a legislature or other governing body, rather than by equitable, civil, or common law. The legal society will try and say that common law is based on judges' decisions, but that's actually called case law, which is stare decisis, and judges don't make law. Everyone should know that there's three branches of government: executive, judicial, and legislative, and the people make the law through the legislative branch. So it's a fundamental principle of law that judges do not make law. They only confirm, affirm, and reaffirm what the law is stated by the people. So if the district attorney is bringing statutory charges, which is penal code, against the people, and a judge is making a decision based on statutes, he can't be making a common law decision, further proving case law is not the common law, because it's based on statutes, and statutes are separate and different than common law. So we learn that common law and statutes are separate and different, and that only lawful courts proceed according to the common law. So if a court is proceeding according to statutes and penal code, then it's not a constitutional court, and an unconstitutional court doesn't have jurisdiction to act, period. It's really that simple. So we know that there are different courts. There's constitutional courts that are courts of record and proceed according to the common law, and there are inferior courts that proceed according to statutes and code. Now here's one that no one can explain. It's from California Jurisprudence, Volume 7, page 841. Self-explanatory. There's no criminal common law in California. All public offenses or crimes are statutory. So let's go to the law books and find out who these courts apply to and who were they made for. "16 American Jurisprudence, 2D, August 2017 update. Constitutional Law, subsection 2, page 4. Distinction between constitutions and statutes." The Constitution is the framework of the government, containing the general principles upon which the government must function. A constitution is made for the people and by the people, and is above all an embodiment of the will of the people, deriving its force directly from the people themselves. Statutes, by contrast, are enactments and rules for the government. Because constitutions constitute the supreme law, they preempt contrary statutes or rules and stand above legislative law. This is the 2024 update. Same book. The Constitution is the framework of the government, containing the general principles upon which the government must function. A state constitution receives its force from the express will of the people. Statutes, by contrast, are enactments and rules for the government. As an expression of the will of the people, a state constitution stands above legislative or judge-made law. So the latest law book tells us the same thing. Statutes are for government, but the district attorney and judges are using statutes against we the people. I'm putting a link to the original American Jurisprudence constitutional law in the link. And this is what it looks like. For a copy of the 2017 and 2024 update, you'll have to set up a Westlaw account to access it, or go to your local library and download it for free. Now there's the people in the private that the common law applies to, and when those people work for the government and are on the clock getting paid, they are now public servants and no longer people in the private while they are on the clock getting paid. And those are the people in government that statutes and code apply to. So it's clear that the Constitution is for the people and statutes are for those working in government. So the constitutional courts, which are courts of record and proceed according to the common law, which are cases of contract, harm, injury, or financial loss, are for the people. And inferior courts proceeding according to statute and penal code are courts for those that did wrong while on the job working in government. Okay, next we have the people of the state of California. Who are the people of the state of California? The people in the private, that's you and me. Next, we're going to go to California Constitution, Article 6, Judicial, Section 20. Now, this one I had to go to the Constitution of 1879 because they left it out on the current Constitution. So the style of all process shall be the people of the state of California, and all prosecution shall be conducted in their name and by their authority. You could compare the Constitution with California Government Code 100. Same thing. So it's clear here that all prosecutions shall be conducted in the people's name and by their authority. So that means if there's no people to prosecute on their behalf of, then the DA has no authority. Let's look at what the district attorney says about only representing the people, not government agencies like sheriff or police, and so on. This is from the Inyo County District Attorney Policy and Procedural Manual, page 32. Attorneys are reminded that, except in very rare cases, the district attorney represents only the people of the state of California in prosecuting alleged criminal offenses and does not and cannot function as an individual legal advisor for officers and does not and cannot function as civil legal advisors for other government agencies. Any attorney employed by the district attorney must make it clear that they are participating only in their role as counsel for the people of the state of California and not as representatives for the agency. So we see here that the district attorney only represents the people and not government agencies. And they must make it clear that their only role is counsel for the people. Counsel is literally means one who assists his client with advice and pleads for him in open court. So that further proves that the district attorney must have one of the people as a party to their prosecution that they are representing, because they only represent the people, and all prosecution shall be conducted in the people's name and by their authority. And since America is a union, the U.S. Constitution, Article 4, Section 1, the full faith and credit clause, means that the laws in one state apply in another state, not statutes but laws. So the laws of Idaho apply here in California. So let's look at the laws of the territory of Idaho, third section, an act creating the office of district attorney. The third section, page 187. They shall be public prosecutors in the respective districts and shall sign all bills of indictment that may be found by the grand jury and shall prosecute on behalf of the people all public prosecutions where the people of this territory are a party. We just learned that the district attorney only represents the people, not government agencies. Only the people. And in order for the district attorney to bring a prosecution in the name of the people, one of the people has to be a party because they are the injured party. And in order for a crime to exist, there must be an injured party. And since the district attorney only represents the people and the superior court proceeds according to the common law, one of the people has to have made a claim under oath of a breach of a contract, harm, injury, or financial loss against the defendant. But that's not happening here because there's no people that the district attorney is prosecuting on behalf of. I've served the district attorney several times and subpoenaed the name of one of the people that's a party to the prosecution, as well as for one of the people to show up and testify, and no one has ever showed up. As you can hear in my other videos, I asked a woman, Amy Lopez, who does at times act as judge, for the name of one of the people that's a party to the prosecution, and she said she doesn't know. It's because they don't exist. And in the other videos, you can hear when I've demanded that the district attorney swear under oath to their claims, and the district attorney refuses to answer, and the judges and commissioners are covering up for them. They refuse to make them answer and are intentionally ignoring the facts and changing the subject because they are all in on the fraud on the people. I thought maybe I could be wrong, so I gave notice humbly demanding by law for the district attorney, every deputy district attorney, every judge, every commissioner, and every attorney in this matter to show the constitutional provision granting their authority to use the people's name and authority to bring a prosecution against we the people in the private, when there is no actual people that's a party to the prosecution that the district attorney claims to be on behalf of. Everyone has failed and refused to show the constitutional provision granting their authority, and constitutional provisions are mandatory. That means if there's no constitutional provision granting their authority to do something, they don't have the authority to do it, period. The sheriff's deputies are standing there watching this go down every day, allowing it to and protecting them. But like I said, they are intentionally and properly trained. Let's go to the California Constitution. Article 1, Section 26. The provisions of this Constitution are mandatory and prohibitory unless express words they are declared to be otherwise. Here's something else that's interesting. Article 3 of the United States Constitution, Section 2. If the district attorney is the state, and if the state is a party to a case, the Constitution says the Supreme Court has original jurisdiction, and the United States Constitution is the supreme law of the land, so something's not adding up. Now let's look at and break down the part that reads, personally appeared before me, who first being duly sworn, complains and alleges. This means someone personally appeared before the officer authorized by law to administer the oath of the person that is complaining, making the allegation. Count 1 reads that a crime of driving when privileges was suspended for prior DUI conviction. Now, this is a huge problem for the district attorney because they know there is no prior DUI conviction because I beat that case, so there's no prior DUI conviction, yet the district attorney still made a complaint knowing this fact. Let's take a look at the public record and see when the case got dismissed and when this one started. File date was November 2021. Case dismissed. Let's see what the charges were. Drive under the influence while blood alcohol level is 0.8 or higher. Driving under the influence of alcohol. Resisting public arrest. Driving without a valid driver's license. Now it reads on here not guilty, but from day one I never pleaded anything. Never pleaded not guilty. Nothing. Never went as far as the complaint. And by pushing that issue that the complaint was a fraud in the first place, they went after me and tried to make it look like I was mentally incompetent or something like that. But as you see here, drive under influence, dismiss before trial. Driving under the influence, dismissal before trial. Resisting public or peace officer, dismissal before trial. Driving without a valid driver's license, dismissal before trial. And the furtherance of justice. Now, in order for there to crime to be to exist, there must be an injured party. So let's look at some maxims of law to prove that. An action is not given to one who is not injured. So what's a maxim? An established principle, a principle of law universally admitted as being a correct statement of the law or as agreeable to reason. an action is not given to him who has received no damages. So that means if there's no injured party claiming damages, the district attorney has no authority to file a complaint because there's no people that are a party to the prosecution that they would be claiming to be representing because they only represent actual people. And one of the people has to be a party to the prosecution. It's a well-established fact that in order for there to be a crime, there has to be what they call a corpus delicti, the body or elements of the crime, which have two elements, which is just the elements of namely being injury, loss, or harm, and the criminal agency causing them to exist. And since the district attorney only represents the people, one of the people must be a party to the prosecution that the district attorney is bringing in their name and by their authority because they are the injured party. So it doesn't matter what the district attorney alleges that you did if there's no injured party, because without one of the people as a party, the district attorney doesn't have the authority to file charges because they only represent the people. And if there's no injured party, then there's no crime. Period. It further reads, all of which is contrary to the form, force, and effect of the statute, in such case made and provided against the peace and dignity of the people of the state of California. Earlier I showed you that statutes, by contrast, are enactments and rules for the government. Not the people. Furthermore, it reads against the peace and dignity of the people. Now that's just silly. Next thing they will do is prosecute you for hurting their feelings. So they clearly tell you that I didn't break a law, but it's contrary to a statute, and it's against the peace and dignity of the people. And there's no actual people that got their dignity or peace hurt, so there's no injured party. And there's no law being broken, so there's no crime. It's just contrary to a statute that doesn't apply to the people in the first place. Now, the Sixth Amendment of the United States Constitution guarantees in all criminal prosecutions the right to confront your accuser. It's called the Confrontation Clause. What it also says is no person shall be held to answer for capital or otherwise infamous crime unless on a presentment or an indictment by a grand jury. Nor be deprived of life, liberty, or property without due process of law. So here's the Sixth Amendment. It's a right to a speedy and public trial, which you saw that went on for 2021. Then it was dismissed in 2023. The Confrontation Clause refers to the provision in the Sixth Amendment of the U.S. Constitution that in all prosecutions the accused shall enjoy the right to be confronted with the witnesses against him. Confrontation means that in a criminal proceeding, the defendant has the opportunity to face the witnesses, cross-examine them, to object to the testimony. It is designed to prevent a defendant from being convicted based on written evidence without having the opportunity to face their accuser and test their honesty and truthfulness before a jury. Now, California has the same thing. The defendant in a criminal cause has the right to a speedy and public trial, to compel attendance of witnesses in the defendant's behalf, to have the assistance of counsel for the defendant's defense, to be personally present with counsel, and to be confronted with the witnesses against the defendant. Now, how can you confront your accuser if there's no people claiming you did them wrong? Remember, because the district attorney only represents the people and prosecutes on behalf of the people. So again, there has to be one of the people that's claiming you did them wrong. so you can confront and cross-examine them to see if they're telling the truth, that you did them wrong. The Constitution guarantees that right, but there's no people actually accusing you, so there is no crime. Now, page 2 reads, subscribed and sworn to before me on. This means that someone signed and gave an oath before the person that can lawfully perform the oath. Now let's get some definitions. Duly sworn. The term duly sworn refers to having been put under oath before an officer authorized to administer oaths in the manner and form required by law. What does attest mean? To affirm to be true or genuine. To authenticate by signing as a witness. To authenticate officially. That's what a complaint means. In context of criminal law, the complainant refers to a person who alleges that another committed a criminal act against him or her. Now let's see who these people are that made this document. Guadalupe is the deputy clerk. Matthew Hamilton is the deputy district attorney that signed as the complainant. And what's the definition of complainant? A person who alleges that another committed a criminal act against him or her. So Matthew is saying, I committed a criminal act against him. Remember, the district attorney only represents the people, and he's not one of the people while on the clock. And I didn't cause him any harm, injury, or financial loss, and there's no contract that he wants to hold me liable for. And he's saying I did something contrary to a statute, and I don't work for the government, so that statute doesn't apply to the people in private. Furthermore, he doesn't have any firsthand knowledge, and he didn't and continues to not swear under oath to what he claims, but he signed it that he did. Subscribed and sworn to before me. Now, Guadalupe is claiming to be true that Matthew Hamilton personally appeared before her, who first being duly sworn, right? Personally appeared before me, who first being duly sworn. Guadalupe, St. Matthew, personally appeared before her, first being duly sworn. That means that she put him under oath and he swore that his allegations are true. Guadalupe further claims that Matthew signed the document and swore under oath before her on this date. This is California Constitution, Article 1, Section 14. Well, they say here, felony shall be prosecuted provided by law, either by indictment or after examination, and committed by a magistrate by information. Well, we know that the United States Constitution says only by indictment. Information is statute. A person charged with a felony by complaint, subscribed under the penalty of perjury, on file in the court where the felony is triable, shall be taken without unnecessary delay before a magistrate of that court. So the Constitution declares that a complaint must be signed and sworn to under the penalty of perjury and filed with the court. Let's go to California Jurisprudence, Volume 7, Preliminary Proceedings, Complaint, Depositions, and Warrant. This is under Signature Verification and Filing, page 966. talks about the complaint need not be verified, but it says that he's personally appeared first being duly sworn. So that's being verified, but it's not. So he lied and filed it. That's fraud. But if it is properly verified and it contains positive evidence of facts tending to show guilt, it may be treated as the deposition required by Section 812 of the Penal Code. Again, that's statute, so that doesn't apply to the people. But it says, since the statute does not designate any particular officer before whom the complaint must be verified, it is necessarily follows that the complaint may be verified before anyone authorized to administer an oath. So it's Guadalupe authorized to administer an oath? Let's keep going. A complaint in a justice court may be verified before a notary public. One before a police judge may be verified before a justice of the peace. And as Section 2093 of the Code of Civil Procedure authorizes the clerk of any court to administer oaths or affirmations, the oath to a deposition taken by a police judge may be administered by the clerk of the police court. Let's zoom in a little bit more. But when a judge of the Superior Court is sitting as a magistrate, he cannot call in the county clerk to administer oaths, as he, when so sitting, has only the powers conferred upon magistrates generally. Let's see what this number 9 here has. Where did they get that from? In Sing, okay, it's reapplication of Sing. That reads here, it is finally contended that the court is without jurisdiction to conduct the preliminary examination threatened because the complaint was verified before a deputy county clerk and not before the magistrate. Let's take a look at that. Deputy county clerk. Subscribed and sworn to before me. The complaint, which initiates criminal proceedings, need not be verified. Because we read that earlier, but that's penal code. So yes, it does have to be, because that's statute stuff that don't apply to us. Whereas if verified, however, and containing positive evidence of facts tending to show guilt, the same may be treated by the magistrate as the deposition required by Section 812 of the Penal Code. Such deposition, however, must be taken by the magistrate, as must all preliminary evidence introducing to show the commission of an offense. We lost it. Let's just start over. If verified, however, and containing positive evidence of facts tending to show guilt, the same may be treated by the magistrate as the deposition required by Section 812 of the Penal Code. Such deposition, however, must be taken by the magistrate, as must all preliminary evidence introduced tending to show the commission of an offense, and that there is reasonable ground to believe that the defendant had committed it. A superior judge assuming the duties of a magistrate, which, if you look up what a judge is of a superior court, they're magistrates, has no right to call in the clerk or any other officer to administer oaths. He sits as a creature of the statute with such powers only as are conferred upon justices of the peace or police judges. It must be held, therefore, that the complaint verified before a deputy clerk cannot be used as a deposition upon preliminary hearing, nor was it a deposition authorizing the issue of the warrant of arrest. Wow. How many warrants are being used in this manner? Sounds like an investigation is needed. The clerks that actually gave me a copy of the complaint, as well as the supervisor Yoli or Yolanda and the manager Lorena Tello for the clerks, told me that they do not have the authority to administer oaths, that they only sign that they receive the documents, and Lorena, the manager, said that that's how they submit the complaint and process the complaint. That's what they do, and that's how they are trained. So Lorena is knowingly colluding with the district attorney, the judges, and the attorneys because she is knowingly with malice improperly training the clerks to file these fraudulent documents, knowing that they do not have the authority to administer the oaths required to swear in a complaint, but they are signing the complaint as if it is true sworn document. The document reads that the complainant, which is the district attorney, with no first-hand knowledge, personally appeared before the deputy clerk, first being duly sworn, then they all sign it as if it's true, and then the clerk files it, getting a court date. And now the judge gets involved and plays his part of the fraud because he knows that the complaint has to be sworn in by him because he's the magistrate. And he knows that the complaint can't be sworn in by these clerks because they are not authorized to do so. That's fraud. They are deceiving the people and the jury because everyone thinks that these complaints are lawful. Then attorneys get involved and do their part to keep the fraud going, making most of these people take deals for crimes that are not even crimes. And everyone is getting paid to commit fraud on we the people. You wonder why the jails and prisons are so full? They're not full of people committing real crimes. As you can see, they are making crimes up and putting people in jail for profit. Now let's listen to the manager, Lorena Tello, actually tell us herself from her own mouth how these complaints are being processed fraudulently.
Yeah, I don't know. From my understanding, I believe she's going to be training, so I don't know when she's going to be available. That's why I'm offering, I can try to help you the best I can.
Okay, have you ever done one of these?
Of course.
Okay, so what was your name?
Vanessa.
Okay, so when it has the name on there,
right?
And have you read one of these before?
I have, yeah.
Okay, so
process them every day.
it reads personally appeared before me, first being duly sworn. So that means they personally appeared before you, right?
Personally appeared before me. Who first? Okay, yeah.
But it's e-filed, number one. So they didn't personally appear, right?
Okay, yeah.
Okay. But it says first being duly sworn, so that means that they swore.
Right.
So you swore the district attorney in for what they said on this?
Well, we don't swear them in, no. We just, what they send over to us, we just process. Not assuming, but they're the ones who file charges.
Okay.
So that's. Hi.
Hello. You're Kimberly?
Yeah, I'm Lorena. I'm her manager.
Oh, okay, because I was asking her on here, because she said she's done one of these before. On the criminal complaint, it reads, personally appeared before me, who first being duly sworn, complains and alleges. So I wanted to know if Kimberly actually swore this stuff in here. Because it says that Bethany personally appeared before Kimberly, first being duly sworn. That means somebody...
The DA's office already sworn us in. They just submit those electronically and we sign them and we just process them.
You're saying the district attorney...
They're sworn in to submit the complaints.
No,
so we don't do it every day. They don't come in every single day. No.
But you have to each case is different.
So they don't.
So they don't do that?
No.
So
they only do it once and it's for everything.
okay, and then right here it reads subscribed and sworn to before me on, and it has the date. So it's saying that they subscribed and sworn, so they signed it and swore before Kimberly on that date.
I'm just telling you that's how they submit them and we file them in.
But it's not true.
Okay, so is there anything else we can help you with? I'm just telling you that's how we submit them. That's our process. That's what we do.
Okay, well, did somebody train you to do it that way, or you guys just...
they were trained.
Because that's fraud, right? I mean, it's a lie. If I said I swore something in and I didn't do it,
not fraud.
Was deceit.
It's not fraud.
Isn't deceit fraud?
It's not fraud.
It's a lie.
Anything else we can help you with?
Oh, I'm trying to just find out what happened here, because if they didn't do that...
We took it in from the deeds office. We signed it. They took it in. You can fight that in court if you like.
Well, I'm attacking the process because...
You can fight it in court if you like. You can talk
you're
to
the
your
manager.
attorney. You have an attorney.
You're the manager,
you have
right?
An attorney.
No,
you have an attorney.
You're a manager,
you have
right?
An attorney.
You're a manager, right?
Anything else you need, sir?
Well, I'm just saying you're a manager and you're allowing
Anything
this.
else
So...
you need, sir? Otherwise, we're going to call deputy. I'm going to telling you what the process is. We always go in circles with you.
Well, because you don't want, you're ignoring the facts.
No, okay.
It's like, you're like, I don't care. I'm doing this anyways. Even though it's wrong and it's a lie, I'm going to do it anyways. That's like what you're saying.
I never said it was wrong and I never said it was a lie.
So you believe that it's wrong then to say that they swore before her and they didn't do it?
No, this is our process. This is what we do.
But it's a lie.
Okay.
So you're agreeing with that?
I'm
That's what I'm saying. Like,
I'm
you're
not
the
agreeing
manager.
with you, sir. Otherwise, do you want
not
to...
agreeing with me. You're
Okay.
agreeing with them
You
saying
can
that
fight
they
this in
did
court.
this.
You can fight this in court.
But do you see how it makes?
Can you fight? You could fight this in court.
But do you see what I'm saying? How it doesn't make sense that they said that they personally appeared before them.
And I'm telling you right now, that's our
in.
process. And if you want to argue that in court, you can do that. I'm not going to continue going in circles with you. I'm not.
It's not. I'm trying to educate you so you can understand. But it's like you're so hard-headed with this. You just don't want to understand.
He just.
Yeah.
He just wants to argue something.
I'm asking her. Okay, check this out. Check this out. Sorry. It says personally appeared before me, first being duly sworn, complains and alleges. Right? Okay. I asked her, did Bethany personally appear before Kimberly and swear to this? And she said no. But it says that she did, and then she filed it.
It's our process. The DA's office process. I told him to argue it in court, and he could talk to his attorney.
But that's
But you have to
wrong.
go to, it's Judge Capitan today, it's not Judge ADR.
Yeah, but that's what I'm saying. Is like,
Did you
how
already
did
go,
she?
did you already go
Yeah,
there
I went
first?
down there. I
Oh, you
talked to
already done with
Ernesto.
court?
No, I told Ernesto I was coming up because I found out.
Oh, Sanchez?
Yeah, I found out that they charged me with new counts here, and I'm
Okay.
like, I came to get this, but it doesn't make sense. If they didn't swear to this, how could you file
I
it?
understand what you're saying. Judge Capitan.
You get it?
I understand what you're saying.
I mean, that's wrong, right? Like, how could you? Like, if I said that I swore to something and filed it, that would be a crime. It'd be filing
Everything
false
that you
document.
bring up to Judge Capitan.
Yeah, I definitely will. But I wanted to get the manager. I wanted to find out from Kimberly what was going on here. And she's like, "This is our process." I'm like, "But do you understand that that's the wrong process? You shouldn't do that."
That's your
So-
opinion, that's
Go
your
ahead and-
opinion, so I get it.
Do it.
Let's just go down to
Yeah,
13.
I will.
Take care
I
of
will.
it with Capitan.
All right, I'm just saying, you know that you're doing wrong, though. Okay, so as a manager,
You continue to give us a hard time.
How am I giving you a hard time?
Because you don't
Am
like
I ever-
our answers. You don't like our answers, and I told you you can fight that in court. You can
am
talk
I ever
your
mean to
attorney.
you?
If you ever mean, I never said you were. Did I? But
You
did
said I give you a hard
I
time.
never said you were mean to me.
Okay,
You said you could
so I'm
go in
coming at
circles.
you and I'm
Okay,
trying to
have a
ask
good
you
day. Have a good day,
questions.
sir. Have a good day.
All right, but you're the manager. That's crazy. Wow. Wow, all this for me?
Yeah, just for you, Gabriel.
Just for you, Gabriel.
This is crazy. Like, because I ask questions. Like, do you guys not
I'll
get
agree
that?
with you.
I ask questions.
It's crazy. Do you have court?
Yeah.
Let's go.
I'm asking questions, and then people get mad because I'm asking questions.
They
It's
don't have all
like,
the answers. The court.
But she's
will
the
have-
manager.
The court will have your answers.
they should have the answers, but I'm saying she's the manager. If she's
Go
teaching
down
these
to
people
where
to
they
do
should
wrong,
have the answers for you.
if she's teaching them to do wrong, like, she shouldn't be the manager.
That's your opinion.
No, because it's not right. It's wrong.
Have a good one.
All right, brother. I'm just saying, man, I've never been out of control with anybody, never done anything wrong. I'm just trying to get answers, right? I'm just trying to get answers.
Now you heard it from the manager, Lorena Tello herself, and one of the clerks. And the men you heard me talking to at the end, those were the sheriff's deputies. There was 6 of them that came in to escort me out of the clerk's office for asking questions. A little crazy, isn't it? And it's crazy that they knew me by name. I have no idea who some of those were, but they knew me by name. Now, I've been threatened and was actually arrested a couple of times for no lawful reason, I believe to intimidate me. I was even robbed by a man, Ernesto Sanchez, who does at times act as a deputy sheriff, who took my cell phone for me for recording the proceedings, and the district attorney actually filed charges against me. I believe it's a form of retaliation for recording them and making these videos exposing their fraud, because there's no law that says I can't record the proceedings. As a matter of fact, there's a law that protects that right. It's called the First Amendment, the freedom of press. Every person, this is the California Constitution, but Amendment 1, Congress shall make no law respecting an establishment of religion or prohibiting the exercise thereof or abridging the freedom of speech or of the press. California has the same one. Every person may freely speak, write, and publish her sentiments on all subjects, being responsible for the abuse of this right. A law may not restrain or abridge liberty of the speech or press. Same thing, personally appeared before me, first being duly sworn, complains and alleges. On or about January 11th, 2024, in the above-named judicial district, the crime of disobeying court order in violation of penal code, a misdemeanor was committed by Gabriel Joe Martinez, who did unlawfully commit contempt of court by willful disobedience of the terms as written of any process or court order or out-of-state court order, lawfully issued by any court including orders pending trial, to wit, California Rules of Court, Rule 1150. January 11th, April 16th, May 20th, May 20th, May 24th, May 24th. Bethany Samarin and Kimberly. Okay, so the order or the complaint reads, willful disobedience of the terms as written of any process or court order or out-of-state court order, lawfully issued by any court, including orders pending trial. Now, I haven't seen a valid court order saying that I can't record, period. And again, it says the crime of disobeying a court order. Now, in order for a crime to exist, there must be an injured party. Where's the injured party? No injured party. Again, it says all of which is contrary to the form, force, and effect of the statute in such case made and provided and against the peace and dignity of the people of the state of California. How did I injure the peace and dignity of the people by audio recording the proceedings? I didn't. It's all made up, just BS. Now let's go see what it said here from California Rules of Court, right? California Rules of Court. Photographing, recording, and broadcasting in court. Except as provided in this rule, court proceedings may not be photographed, recorded, or broadcast. This rule does not prohibit courts from photographing or videotaping sessions for judicial education or publication, and is not intended to apply to closed-circuit television broadcast solely within the courthouse or between court facilities if the broadcasts are controlled by the court and court personnel. So they're saying they can do the recording, but we can't. Now, I recorded audio, and I made videos of it, and I put the judges showing the fraud that they're committing, the district attorney that they're committing, and they're charging me with 6 counts of disobeying a court order. But you can buy the audio recordings for $75. Doesn't make any sense. Why would I pay $75 for a recording of the proceedings when I can do it myself? And then I can record everything else that's going on in there. Well, let's go down here to the media coverage, right? We got the First Amendment. The First Amendment of the Constitution protects this right of the media, of the press. It says media coverage may be permitted only when written order of the judge as provided in this subdivision. I don't need permission. The Constitution protects this right. So it says down here, though, this rule does not otherwise limit or restrict the right of the media to cover and report court proceedings. They just contradict themselves. Maybe they're just hoping people don't catch that and see that. I don't know. But there's no law that says that you can't record in there because the law says you can record. Now, the district attorney, judges, attorneys, and public defenders that are working in our courthouse are all members of the Bar Association. I'm not saying all members are bad. I'm just pointing out that they are all members of the same organization. But it's the man or woman that makes the decision and liable for their own actions. They all swore an oath, or should have, as I'm finding out, some of them have not sworn an oath. You can do a free open records request at the county clerk's office online for any employee's filed oath of office and bonds that is required by law to work for the people. And I'm finding out that there are judges with no proper oath, and I still haven't got any of their bonds. California Constitution, Article 20, Section 3. The members of the legislature and all public officers and employees, executive, legislative, and judicial, except such inferior officers and employees as may be by law exempt, shall before they enter upon the duties of their respective offices take and subscribe the following oath or affirmation. I do solemnly swear or affirm that I will support and defend the Constitution of the United States and the Constitution of the State of California against all enemies, foreign and domestic, that I will bear true faith and allegiance to the Constitution of the United States and the Constitution of the State of California, that I take this obligation freely without any mental reservation or purpose or evasion, and that I will well and faithfully discharge the duties upon which I am about to enter. Now they took this part out, which is crazy. because this part is important, and it seems to me that this is exactly what they are doing, overthrowing our form of government, which is the Constitution they swore to uphold. And I do further swear or affirm that I do not advocate, nor am I a member of any party, organization, political or otherwise, that advocates the overthrow of the government of the United States or of the state of California by force or violence or other unlawful means. That's crazy that they took that out. Now let's read who they were talking about when they wrote all public officers and employees. They got a definition: public officer or employee. Includes every officer and employee of the state, including the University of California, every county, city, and county district, and authority, including any department, division, bureau, board of commission, agency, or instrumentality of any of the foregoing. That's pretty specific. It includes every state, county, and city employee. They all have to swear to uphold the United States and California Constitution. That's the contract they make to work for we the people. That means every employee has to support and defend our rights secured in the Constitution. And nowhere does it say that they will support and defend statutes or code, does it? Our form of government is outlined in our constitutions. So those who swore the oath and go against the Constitution and violate our rights, are they not literally overthrowing our form of government or warring against we the people? Someone called that insurrection and treason. I'm just exposing the truth, so you decide. Now, who's responsible for upholding the law, and who is in the courtroom watching all this happen to the people? Now, who's responsible for protecting the people's rights? It's the Fresno County Sheriff. His name's John Zanoni. And who's in the courthouse and the courtrooms every single day watching this happen? The Fresno County Deputy Sheriffs.
Repeat after me. I state your name.
I, John Zanoni,
Do solemnly swear
do solemnly swear
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies,
against all enemies,
foreign and domestic,
foreign and domestic,
that I will bear true faith
and that I will bear true faith
and allegiance
and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well and faithfully
and that I will well and faithfully
discharge the duties
discharge the duties
upon which I am about to enter,
upon which I'm about to enter.
so help me God.
So help me God.
Congratulations, Sheriff Sonoma.